Thank you, everyone. Please be seated. We are here today for 3 separate oral arguments. The first one is Lewis versus Howard Allen Investments et al. The second one is Ryder versus Segal et al. And the third one is Costaglanis versus Yates et al. We will begin with the Lewis case, and let's do a little bit of a sound check. For the attorney's information, we have 2 justices that will be participating via video conference, Justice Brent Apple and Justice Matthew McDermott. So I will start with, it's my understanding, Mr. Bevel, you will give the first 10 minutes, and Mr. Verhulst will do the last 5, is that correct? Thank you. I'll leave it up to you guys to figure out how to divide that time. Mr. Bevel, if you'd like to do a sound check quick, and then I'll start with the other.
Testing. Does that work?
Could I hear from both Apple and McDermott?
It does for me. Thank you.
Works for me. Thank you, counsel.
Thank you, Mr. Bevel. And it's my understanding Mr. Eashaan Vajpeyi will be arguing for the appellant. Would you please do a sound check?
Testing.
Very good. Thank you.
Thank you again, counsel.
Okay. Mr. Vajpeyi, you may begin.
May it please the court, counsel. I represent plaintiff Christina Lewis today, and she requests that the district court order in this case be reversed and that this court grant her motion for summary judgment, deny defendants, and allow this case to proceed to trial against Howard Allen Investments, Inc. In this case, both sides filed motions for summary judgment to determine whether defendant Howard Allen Investments, Inc. was a landlord under Iowa Code Chapter 562A, Iowa's adoption of the Uniform Residential Landlord-Tenant Act. Finding him as a landlord would make him liable under that code section's responsibility to maintain a fit and habitable premises. The district court granted Allen Investments' motion for summary judgment, dismissing it from the case. There were several other corporate defendants and Mr. Allen individually that were effectively severed for purposes of trial, although they did take part in the summary judgment briefing and this appeal. In order to ripen the case for final appeal, defendants De La Rosa and Rodriguez were also voluntarily dismissed by plaintiffs. The district court's error was in focusing on issues of control of the premises and looking to the common law for its guiding principles in determining who is a landlord and who held legal title to the property at issue. The district court analyzed the issue as if there was no statutory framework that provided an alternate and more specific definition of those terms in this specific context. But there is a very specific statutory framework here that clearly defines who is a landlord and who is liable to maintain the fit and habitable premises in a residential landlord-tenant relationship. And it's within that framework that these definitions need to be analyzed. There is
Counsel, let me ask a question. This is not an action brought under the Landlord-Tenant Act, I take it. It's a common law negligence action. Does that matter? In other words, could it be that the broad definition of owner would apply in an action under the Landlord-Tenant Act, but not in a common law action?
Thank you, Justice Apple. Plaintiffs did plead common law premises liability claims in the petition, but also did specifically reference claims under the Landlord-Tenant Act for violation to maintain the fit premises. So you say you have multiple claims. You do have a claim under the Landlord-Tenant Act. Yes, sir. Yes, Justice Apple. So the language of the Landlord-Tenant Act is clear and unambiguous. It provides a very specific definition for landlord. It provides a broad definition. It provides a very specific definition for owner. And again, it provides a very broad definition.
Counsel, if I might, in the definition of landlord in 562A.6 sub 5, we have the word or, so it's landlord means the owner, lessor, or sub-lessor. Doesn't that suggest to us that it means that landlord refers to one of those things, but not to all of those things, or not to multiple of those things?
I don't believe so, Justice McDermott, because, and this goes to defendant's argument that we need to look to the written lease to determine which of these parties is the landlord. And if that were the case, you wouldn't need owner. You would only need the term lessor or sublessor, because the lessor is who's on the lease. They are the leasing party. There is this fourth category of manager who doesn't make required disclosures as to the ownership, but that's not really here or there. So this contemplates, in my view, a non-lessor owner, and then it would also contemplate the lessor. I mean, the fact that they go on to define owner so broadly, and looking at the purpose of this statute, which is to provide for safer, better residential leased properties, I don't think it is limited. Turning back to the district court's order.
How about the unless the context otherwise requires language? Can't we say that in this context, where you're talking about a contract seller who is distant from the day-to-day management of the property, they really shouldn't be considered a lessor or whatever under the Landlord-Tenant Act?
Well, I don't know that a contract seller in the day-to-day management of a residential leased property is really going to be that much different than a regular owner of the property in terms of that control aspect, in terms of that day-to-day management. I mean,
But it says owner, the landlord means an owner unless the context requires otherwise. Why can't we say here the context requires otherwise? Because you've got a direct lessor that is, the primary lessor here, but you want to go behind that lessor to this contract seller, right?
correct. And what I was trying to clarify is that the contract seller and an owner of this property, I don't think are functionally very different, thereby not requiring the context to interpret in the manner you're suggesting. An owner, a contract seller, they're going to be delegating much of these duties.
Language suggests that sometimes the context will otherwise require, and therefore a landlord doesn't include an owner. Couldn't this be one of these situations where landlord does not include owner?
I suppose in the sense that in the context, unless the context otherwise requires, I guess you could read that as broadly as you choose and decide that this is a case as you suggest. But I think the fact that these definitions are so specifically set forward that these definitions meant for the net to be cast as widely as possible. And so we're getting into the situation, the argument of control and things like that. Owner means legal title holder. And the statute goes on beyond just legal title owner to say someone with a beneficial.
In this case, did the contract seller exercise any control over the day-to-day operation of the property?
That's not in the record, Your Honor. I mean, he did not exercise any control over the day-to-day management of the property.
And did the contract seller have a right of control over the day-to-day management of the property under the lease?
Under the written residential lease agreement, I don't believe so. The actual lease document has not been produced in this case because the lessors, strictly speaking, De La Rosa and Rodriguez, did not produce a copy, and my client's copy was lost in the house fire.
Ordinarily, liability follows control, and that makes sense because the party in control can implement safety measures or at least be, able to do that. Does it make sense to have a contract seller who's distant from the property, who's not running the place, accountable for a fire?
An owner would be accountable for the fire. Just the fact that he's the contract seller doesn't change things. He owns the legal title. An owner of one of these high-rise complexes typically is going to delegate duties, maybe have a leasing company, have a management company, but I believe they would be liable. I think the distinction here that is trying to be created is this contract seller relationship, contract buyer relationship.
What rights would the contract seller have to enter the property?
I don't believe that as long as the terms of the contract are being met and fulfilled, that the contract seller would have the right to enter the property. So that is something that we obviously admit, but
And I take it that you would agree then the contract seller also has no right to make adjustments to the property, fixes, remediate deficiencies in the property. All of those things presuppose some right of entry. Isn't that right?
that's true, but liability follows control in the common law, at common law. Here we have a very narrow, very specific statutory scheme. It does not involve commercial leases. It does not involve the contract sale of single-family owner-occupied homes. It does not involve traditional bank mortgages, financing for the homes that most Iowans buy. It deals with specific residential landlord-tenant relationships, and I think the broad language.
Counsel, if I might, on that point, in 562 A.5 sub 2, it refers to exclusions from application of chapter. And sub 2 says, excluded from this chapter are occupancy under a contract of sale of a dwelling unit or the property of which it is a part, if the occupant is a purchaser or a person who succeeds to the purchaser's interest. As I read that, what it's saying is that the buyer under a contract sale is not in a tenant-landlord relationship with the seller. So here that would be the investment entity. So if the owner is not in a tenant-landlord relationship with the buyer, how can we find here that the owner is in a tenant-landlord relationship with the buyer's tenant?
Well, the tenants are not the contract purchaser under that exclusion. And you can find that because that's what this statute contemplates. This was what this statute requires. It casts such a broad net of liability for a very specific purpose that someone in the position of my clients, Christina Lewis and her fiance and her children, are to be protected against these properties, these convoluted ownership agreements, whereby where this property with no smoke detectors or fire extinguishers is this hot potato between owner, seller, contract purchaser, and the victims are these everyday Iowans who rent property as opposed to being able to afford to buy property. And I think that is the purpose of this act, and that is exactly what the legislature intended when they enacted these broad provisions.
Counsel, are you aware of the case of Hoyser versus McGraw from 1985?
Hoyser v. McGraw?
Right.
I don't believe I've read that extensively, Your Honor.
So in that case, it was a farm operation where the father and the son owned a partnership that had the farm operation, and they had an employee who lived in a house that was owned by the mother. Are you aware of that case from those facts?
Possibly. I've read a few farm cases on this.
And in that case, the house was actually owned by the mother, and the tenant was an employee of the partnership. And in that case, we said because the lease was not, there's no way that we could find that the lease was with the mother, who was the owner of the house, there's no way that she could be liable as a landlord. If you're not familiar with it, then you can't respond to it, apparently.
Yeah, I'm not familiar with it, and I don't know if it precedes enactment.
It did not. It was a 1985 case, and we specifically said under Chapter 562A, there was simply no way that she could be a landlord.
Okay. Well, yeah, I'm not familiar with that case, but the owner is,
But I think that case seems to bring to the point of, we can talk about who's an owner and who's a landlord, but when you look at the specific provision, it says the landlord shall. And so is it possible that the definitions provide who could be a landlord, but then the obligations are imposed on who actually is the landlord for a particular property? And in this case, the landlord is the person who had the lease agreement, the lessor, and is not the contract seller.
I suppose I turn back to my reasoning that the owner is the person who has the legal title, and if it was, as you suggest, the language would be different. The language would suggest, it would talk about control. Maybe it wouldn't define these things as particularly as it does. It would exclude from the definition of landlord owner who owns legal title. It would simply state the lessor. It would simply state the party with whom the tenants have contracted, but it goes so far, and I'll wrap up right now, but
Thank you, you may.
it goes so far as to specifically separate in the definition of owner the person who owns legal title or the person who has the beneficial ownership and enjoyment of the premises. And it even goes to say that a manager, and that goes to control, but someone who has no property interest in this, might not be making any money off of this, could be liable under this act. And so that's just the broad interpretation that my clients urge this court to take and to allow the words of the legislature to stay put. So, thank you.
Thank you. Mr. Bevel?
May it please the court, counsel. My name is Henry Bevel, and I am here representing Howard L. Allen Investments Incorporated and Howard Allen individually. I will take the first 10 minutes of the argument. Thomas Verhulst, who represents a group of companies collectively referred to as Metro Investments et al., will take the last 5 minutes of the argument. The goal in interpreting a statute is to determine or ascertain legislative intent. When we look at the general definition section of the Uniform Residential Landlord and Tenant Act, which is contained in Section 562A6 of the Code of Iowa, we just don't go to the word we're looking for. We read the entire statute. And that statute has an introductory paragraph that provides, subject to additional definitions contained in subsequent articles of this chapter, which apply to specific articles or its parts, and unless the context otherwise requires in this chapter, and then you have a colon, and the words that are defined then follow. The definitions section, or the definitions provision for this statute clearly state that context, the circumstances, the setting is to be considered in applying the definitions of the Uniform Residential Landlord Tenant Act.
Let me ask this question, Counsel. Couldn't we approach this language, rather sweeping definition, as an expression of the legislature to, it's a creditor's remedies provision. It's to make sure that under the Landlord Tenant Act, there's a solvent party responsible. So in other words, you toss in an owner who has no control. It's a little bit like the automobile case where you have vicarious liability when a owner allows a licensee to drive the car and ends up with an accident. Why can't we approach this as saying, well, the legislature wanted to make absolutely certain that to the extent there was a violation of the Landlord-Tenant Act, there would be some financially responsible party?
Justice, I think if you look at section 562A16, which I believe covers the what happens if a premises or property is sold and that property is under a lease or a rental agreement. Upon notice, the seller is relieved of liability upon notice to the tenant. And it seems to be that, again, that goes to control, and it goes to, I don't know, it doesn't seem to me that that provision seems consistent with the context otherwise requires language.
Mr. Bevel, maybe I'm shifting gears a little, but this is a question that was raised with Mr. Vajpeyi. What kind of a claim has this injured party brought? Is it a claim for violation directly of the Landlord-Tenant Act, or is it a negligence claim asserting negligence per se based on a violation of the Landlord-Tenant Act, or is it both?
The petition contains a negligence action. And in that petition, it asserts several particulars of negligence, one of which is a violation of the Landlord-Tenant Act. So it is, I believe, actually, it's been admitted in some of the documents that this is a negligence action.
Well, the remedies sought are remedies traditionally associated with a negligence action, I think. Correct me if I'm wrong. I mean, this is a nice question. Although the Landlord-Tenant Act is mentioned in the pleading and so forth, it seems to me that there's at least a question as to whether this is an action at all under the Landlord-Tenant Act. The argument seems to be maybe that there's a duty, a statutory duty that should be considered a negligence action. But is that how you read the complaint?
I think that is the issue, that whether there's a duty. And that's why I consider it a negligence action. The context, the circumstances, the setting, those are the factors that support the district court's denial of the plaintiff's motion for partial summary judgment and the district court's granting of the defendant's motion for summary judgment. The context, the circumstances, the setting established by the uncontroverted facts of this case established that Allen Investments sold the property locally known as 323 Archer Street, Waterloo, Iowa, on contract on November 10, 2009 to Mr. Escobar and De La Rosa. This sale is almost exactly, it's 3 days short of being 5 years from the date of the November 7, 2014 fire that gives rise to this lawsuit. There was no lease or contractual relationship between Christina Lewis and Allen Investments. The lease was signed by Mr. Rodriguez de la Rosa and Ms. Lewis and Mr. Thomas in the summer of 2014, 4.5 years after this property had been sold. Additionally, 323 Archer is a single-family home. There are no common areas over which Allen Investments shared or maintained control. When we talk about the particulars of negligence alleged by the plaintiff, the failure to install adequate smoke detectors, the failure to maintain adequate smoke detectors, a failure to provide or install working adequate fire extinguishment devices, the failure to warn of a dangerous and unsafe condition on the premises, the failure to provide a fit and habitable premises pursuant to Iowa Code Chapter 562A. In order for the Allen Investments to have knowledge of these issues and to address them, they would have to have access to the premises. And there is nothing in the record establishing that they did or at any time had control.
There's kind of the oddity. I mean, the statute says that the landlord does get access for certain purposes, which maybe Escobar and De La Rosa would have objected to. But if landlord always means landlord, it strikes me there's a number of provisions here that maybe don't make a whole lot of sense in the Landlord-Tenant Act as applied to this case.
I'm scratching my head. But I still think we come back to context. And context, the circumstances, the setting. In this case, the record is clear that Allen Investments did not have access. It is clear that it did not have control. When they sold the property on contract, they released possession, the right of possession. And it's clear that they never had a lease agreement with Ms. Lewis. The lack or absence of a duty owed by Allen Investments is established when the uncontroverted facts of this case are viewed in context and in terms of the absence of control of the property by Howard L. Allen Investments, Inc. It is admitted that the Howard L. Allen never had any ownership in this property individually. In Stalter by Stalter, this court stated, the rationale underlying the general rule that one who has transferred ownership and control is no longer liable is that the former owner no longer has control and thus may not enter the property to cure any deficiency, and she cannot control the entry of persons onto the property or provide safeguards for them. There is no evidence in this case of access or control by Allen Investments, and we'd ask that the court affirm the district court.
Counsel, I just have one question before you sit down, and that is, why did the legislature put owner into the definition?
I think because it's possible that they could be an owner selling a property on contract. I think they would become a mortgagee in possession that under those circumstances. So, and I think Mr. Verhulst will address that. Thank you.
May it please the court, counsel. Justice Appel, I want to address those questions that you've just raised because that's really the key here. We have a negligence case here where the issue becomes who has the duty in this particular case. And when the legislature added owner to the statute, what the legislature was looking at is not for a deep pocket, but they're looking at a certain context where a contract seller who holds bare legal title could have the obligations and duties of a landlord. What's that situation? Well, let's say the contract purchaser defaults or breaches on the contract. If they do so, the contract vendor is going to step in, start forfeiture actions, foreclosure actions. During that process, they now have gained control and access to the property. And when it is completed, they step in and take over the property and control of it, subject to the tenancy. So in that situation, the legislature has addressed it by using the word or and throwing owner in there because there can be a situation where the lessor.
It strikes me that runs into the language that runs up against the language Justice McDermott quoted, but it does strike me that maybe why you might want owner in the statute is there are sort of informal arrangements where, let's say, I'm letting Justice Oxley for a period of time stay in my home, I'm not there, and we don't have anything formal, there's nothing in writing, but it might be that the Landlord-Tenant Act wanted to be able to cover that situation. And I would be considered an owner, but if somebody said I'm a lessor, I'd say, well, I'm not a lessor.
Yeah.
So maybe that's what they're driving at. Is that possible?
That's possible, but we don't have evidence that that's what happened in this particular case. In this particular case, it was sold on contract. The contract vendor has had no interest or access or control to the property. And if we are to take the expanded definition that the plaintiff is arguing, that we need to change it from or to and we have to include the contract vendor, then all contract vendors have all of a sudden become landlords and across the state of Iowa, and they now face a duty, which is a problem for them, because if they have a duty as a landlord to fulfill the obligations, they can't do it because they have a real estate contract that does not allow them to have control or access to the property. So it's a pretty easy case now for a plaintiff to hold a contract vendor responsible or liable, because you have a duty statutorily, but under the contract, you have no way to perform those duties because you have no right of access or control of the property, nor do you have any privity of contract with the tenant. And that would not only apply to a seller-based sale, but let's say we had a situation in which we have a third-party lender involved. Although we don't have this happen very often, but third-party lenders sometimes use what's called a deed of trust. And if a deed of trust is given to a trustee to take care of a lendor, and to provide that security interest, guess what? That trustee under that deed of trust has bare legal title just as a seller does on a contract vendor. So are we going to hold them responsible when they probably have never had control of the property, never have access, and all of a sudden they're stepping in and becoming a landlord for tenants they've never seen before? And where are they going to get insurance to cover their liability? Because what insurance company is going to cover liability for a trustee or a contract vendor who has a duty but cannot perform the landlord duties to cover and make sure that they take care of their tenant? We probably have a similar situation. Oh, I guess I see that I'm stopped, so I appreciate your time.
If you'd like to wrap up.
I was going into a whole other area, so I guess.
Oh, probably a good time to stop then.
Yeah.
Thank you. Before you get started, I have a question right away. If we were to follow your argument, it seems to me what I'm hearing is you want to put the burden on the owner, but not the benefits. For example, I'm making these numbers up, totally nothing to do with the record. But if this property was sold for $100,000 5 years ago, and now it's because maybe the property, just the venue, the area is super popular in Waterloo, and there's big bucks, and it's going to be sold for double, are you going to allow that owner to share in that profit?
Thank you for that question. It dovetails with a point in this record that does exist, which is that Howard L. Allen Investments, Inc., when the house burned down, took the insurance money for the payout on the property casualty line, demolished the home, and because the entity always held the deed, never relinquished that deed, owns that bare land. And in the contract seller scenario, if the contract purchaser is the most dutiful contract purchaser, then perhaps in that real estate market appreciation scenario, they would not be able to share. But part of the reason, there's benefits to the contract sale situation that inure to both the purchaser but also to the seller, in that there are quick and easy, not necessarily easy, but upon a breach of the contract by the purchaser, there are fast-tracked forfeiture rights, fast-tracked foreclosure rights, the ability to have taken payments for years and years and years from the buyer, have them breach the contract, foreclose, and have total forfeiture of all those payments. So there's a quid pro quo there they're allowed to sell to someone who might not traditionally have bank financing. And so that benefits the purchaser, but it also benefits the seller who might have, in this case, a property very, the appeal of this property is questionable. It was a derelict property. And so he's able to find these two guys that he finds at a Mexican restaurant to buy this house on contract, and he just throws it at them. And you're not going to find a reputable investor to buy this. And so there's that quid pro quo there. I want to really quickly turn on this. The 562A.16, that is clearly not the case here. That is contemplated for when a property is mid-lease and one owner conveys legal title. So they sell the property, they convey the legal title, the deed passes. So of course the new owner is going to be liable and the old owner is not. There was no conveyance of legal title in this case, so that is a red herring. Second, the issue of whether this case is brought under the Landlord-Tenant Act, I don't know that that was ever raised. The district court analyzed it as being argued and brought under the Landlord-Tenant Act. The Landlord-Tenant Act doesn't necessarily provide specific remedies for pain and suffering, loss of consortium, mental injuries. It talks about, just deposits and treble damages and attorney's fees and that. So in a negligence claim like this, you'd bring it under those duties. Or in a personal injury case like this, you'd bring it under those duties from the act.
I'm sorry, I want to go back to that question I asked you. Were the insurance proceeds less than the balance owed on the contract?
I don't know exactly, Your Honor. There is testimony in the record, to be fair, that it was contemplated to cover the purchase price, but I don't think there's any evidence that the purchase price greatly varied from the actual market value. And
who owned that insurance policy?
Howard L. Allen Investments, Inc.
They were the ones that carried the policy?
Yes,
I thought it
because
was,
Howard L. Allen Investments, Inc.
I
yes.
knew that they got the proceeds, but I thought it was in the record that they were not the owner of the policy.
No, they carried
They
the
did?
policy.
Okay.
And because they're the deed holder. I mean, we're talking about what insurance is going to do, which, first of all, totally inappropriate question to be talking about, but they're not going to write a policy for Escobar and Flores. They're only going to write a policy for the deed holder. And that's a situation that obviously the Landlord-Tenant Act contemplates, is they don't want these contract sellers going around selling and then having them leased, and then an insurance company saying, we can't insure this property for casualty or personal injury liability because you're the owner. I mean, I don't know who's going to write it to the lessor. Stalter v. Stalter, that's a case in the common law where a guy runs into a utility line standing on a railroad car. It could be it's the furthest thing from a landlord-tenant relationship. And very lastly, yes, Justice Mansfield, Howard L. Allen Investments, Inc., while not availing itself of the right to enter the property, could have entered the property. It's an owner, it's a landlord, and upon reasonable notice under the Landlord-Tenant Act, it could have entered, it could have made sure it was safe to protect its interests. And maybe that's an oddity of this statute, but it is the way it is. Thank you.
Thank you. Lewis versus Allen et al. Is hereby submitted. And we will have a transition period where things are sanitized for the next case. As soon as the first set of attorneys have gathered their material and exited the area, then the next case attorneys can approach and get situated as well. And we'll once again do another sound check before we get started.